Today I'll be discussing on the topic the judiciary. As we know that there are three organs of the government. One is the executive, the second is the legislature, and the third is the judiciary. And three of the organs or the pillars of the government has got its different functions. The first is that which one is the executive. Its main function is to execute the laws. The legislature work is to make the laws, and the judiciary's role is to interpret the laws. Among the noble aims and objectives of the Constitution, and that is the founding fathers accorded the highest place to justice. As we know that the preamble speaks of we the people of India resolving to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political to all its citizens. So you see that justice is placed higher than the other principles of liberty, equality, and fraternity in the preamble. Again, the preamble clearly enjoins precedence to social and economic justice over political justice. See, people turn to the judiciary in the quest of justice. There is a need to review the working of the judiciary during the last half a century and more to assess how far our justice delivery system has been able to ensure equal social, economic, and political justice to all the people as ordained by the Constitution of India and its preamble. See, the Constitution lays down all the structure and defines, delimits, and demarcates the role and functions of every organ of the state, including the judiciary, and establishes the norms for the interrelationship, checks, and balances. And we know that independence of judiciary is essential to the rule of law, and it is one of the constitutional norm too. Or you can say that independence of judiciary is the basic structure of the constitution too. Now you see the structure of the judiciary. Where are the provisions of judiciary mentioned in the constitution? See, provisions in the regard to the judiciary, it is contained in part 5, which is titled as the Union, and under chapter 4, title the Union Judiciary, and part 6, the States, under chapter 6, titled Subordinate Courts respectively. Now you see, in India, though the polity is dual, the judiciary is very much integrated. For the entire Republic of India, there is one unified judicial system, one hierarchy of courts with the Supreme Court as the highest court, and also the arbiter in matters of relations between the union and the states, and the states interstate. Now the hierarchy of the Indian courts. See, there are different levels of the judiciary system in India, empowered with distinct type of courts. The courts are structured with very strong judiciary and hierarchical system as per the powers bestowed upon them. The system is strong enough to make limitation of court with its jurisdiction and exercise of the power. The Supreme Court of India is placed at the top of the hierarchical. See, we know that the Supreme Court of India is placed at the top of the hierarchical position, which is followed by the high courts in the regional level and the lower courts at the micro level, with the assignment and powers and exercising of the same for the people of India. Now you see the first, which is at the apex court, that is the Supreme Court of India. It is the highest level of court of Indian judicial system, which was established as part 5, chapter 4 of the Constitution of India, which endorses the concept of Supreme Court as a federal court to play the role of the guardian of the esteemed Constitution of India, with the status of the highest level of court in the status of appeal cases. We know that when we see the hierarchy of the courts in Indian system, the Supreme Court is the highest court. It is at the topmost level. It is the apex court and everybody is bound by it. Everybody is bound in the hierarchy of the courts by the decision of the Supreme Court. Every other court is bound by the Supreme Court. And you know, the most beautiful part or most unique part of the Supreme Court is that it can go beyond the Constitution, but it should be in justice, good conscience, and equity. Now you see the constitutional regulation as per for the Supreme Court. See, As conferred by Articles 124 to 147 of the Indian Constitution, the jurisdiction and composition of the Supreme Court is being fixed. The court is primarily of the status of the appellate court. This court is accepting the appeals of cases which are being heard in the high courts situated in different states and union territories with dissatisfaction of related parties. This court also accepts writ petitions with the suspected occurrence of activities which may infer about violation of human rights, and subsequent petitions are accepted to hear and judge the consequence of such happenings. This type of petitions are accepted under Article 32 of the Indian Constitution. This article confers the right to ensure remedies through constitution. This court also hears about such serious issues which need to be attended with immediate attention. Now, the structure and application of the Supreme Court. The Supreme Court is comprised of the Chief Justice along with 30 other judges to carry on the operation of the court. The proceeding of the Supreme Court is being heard only in the language of English. The Supreme Court is governed by the Supreme Court rules which was published in the year 1966. The same has been fixed under the Article 145 of the Constitution of India to ensure the regulation of the procedures and practices of the Supreme Court. This article is passing through the process of upgrading with the presently enforced article as per the Supreme Court Rules 2013. Now, the next is the High Court of India. High courts are the second courts of importance of the democracy of India. They are governed by the bindings conferred by the Supreme Court of India so far judgments and orders are concerned. The Supreme Court of India is the highest level of courts and are responsible for fixing the guidance to the High Court set by precedents. High courts are a type of courts which are instituted as per the courts powered by the Constitution with the effect of Article 214, Part 4, Chapter 5 of the Indian Constitution. There are around 24 high courts in India taking care of the regional juridical system of India, out of which Kolkata High Court is the oldest one. Now you see the jurisdiction of the High Court. These courts are mainly confined to the jurisdiction of the state, group of states or union territories. They are being empowered to govern the jurisdiction of lower courts like the family, civil and the criminal courts with other different courts. So far as the originality of the jurisdiction is concerned in the related domain of the states and the other distinct courts. These courts are treated as a subordinate to the High Court by status. But high courts are mainly exercising their jurisdiction relating to civil or criminal domain if the lower courts are proved incapable of exercising their powers as per authorization extended by law. This situation may be generated through the inability of the financial or territorial jurisdiction. There are specific areas in which only High Court can exercise the right for hearing like cases related to company law as it is designated specially in a state or federal law. But normally the high courts are involved in the appeals raised in the cases of the lower courts with the writ petition as conferred in Article 226 of the Constitution of India. The area of writ petition is also the sole jurisdiction of the high courts. The jurisdiction of the high court is varying so far the territorial jurisdiction is considered. Now, the official structure and application of the High Court. The appointment of the judges of the High Court are being executed by the President of India with the consultation of the Governor of the state or union territory. The High Courts with handling of most of the case of a particular area are provided with the facility of permanent benches or branches of the court situated there only. To serve the complainants of remote regions, the establishment of circuit benches had been made to facilitate the service with the schedule of operation as per the occurrence of visit of the judges. See the lower courts. Now the next, as we have seen that at the first and foremost the apex court level, that is the Supreme Court, the second is the High Court, and the thirdly you can see that the lower courts. And out of that there is a district court. And what is the constitution of district court? See, the basis of structuring of district courts in India is mainly depending upon the discretion of the state governments or the union territories. The structure of those courts are mainly made considering several factors like number of cases, distribution of population, etc. Depending upon those factors, the state government takes the decision of numbers of district courts to be in operation for single districts or clubbing together different adjacent districts. Normally, this type of courts exercise their power of juridical service in district level. These courts are covered by the administrative powers of the high courts under which the district courts are covered. The judgments of the district courts are subject to review to the appellate jurisdiction of the respective high court. Now you see the structure and jurisdiction of the district court. They are mainly run by the state government appointed district judges. There are additional district judges and assistant district judges who are there to share the additional load of the proceedings of the district court. These additional district judges have equal power like the district judge for the jurisdiction area of any city which has got the status of metropolitan area as conferred by the state government. These district courts have the additional jurisdictional authority of appeal handling over the subordinate courts which are there in the same district, especially in the domain of the civil and criminal affairs. The subordinate courts covering the civil cases in this aspect are considered as junior civil judge court, principal junior and senior civil judge court, which are also known as sub-court, subordinate courts. All these courts are treated with ascending orders. The subordinate courts covering the criminal cases are second class judicial magistrate court, first class judicial magistrate court and the chief judicial magistrate court, along with family courts which are founded to deal with the issues related to disputes of matrimonial issues only. The status of the principal judge of family court is at par with the district judge. There are total 351 district courts in operation, out of which 342 are of states and while 9 are of union territories. So this is basically used all about the judiciary and also the hierarchy of the courts. I'll be discussing more on the hierarchy of the courts in the later class.